biggest misconception clients or people have of you as a lawyer?
They're out to suck your money.
Today we're joined by Ivan Lee, partner at PDLegal LLC. Specialising in civil and commercial litigation, Ivan has led numerous high-profile cases in Singapore's High Court and State Courts, including in his very first year, a 10-day High Court trial. $1 billion today, tomorrow, would you still be a lawyer? Yes and no, and why?
I think I would, but
Welcome to the show, Ivan.
thank you, Jonathan, for having me.
Okay, let's go straight into the questions and let's begin perhaps by understanding a bit about how you arrived here. So what got you into law?
Okay, so I'm not going to give you the typical interview answer.
Yeah.
I actually didn't know what to do.
Okay.
Right, so I was really conflicted between two choices: a business-related subject because versatile degree,
Yes.
or law. Right?
Yeah.
Eventually, I ended up choosing law because, I think it's been ingrained in me in a young age because my uncle is quite an established lawyer, and I have very fond memories of going over to his house on Sundays and seeing him playing Diablo 2.
Wow.
Right, so to me, it was you're clearly very successful and you have time to game. That's a career I want to be in. To be frank, I didn't find it to be my calling until I was about 4 months from being called.
I see.
Yeah.
So maybe let's just very quickly just go into that a little bit.
Sure.
When you're 4 months away from qualifying as a lawyer, that's means getting called. What changed?
Okay, so the thing was this thing called a part call, where the courts grant permission to certain law graduates who are going to be called to the bar soon, privileges to attend court by themselves. Certain conditions have to be met, but I met those conditions around 4 months before being called. And at that point, I was in a small law firm, about five or so lawyers, very tightly knit, still my good friends till today. It was really deep end training. So they would assign you a case, you handle it yourself. You reach out to the seniors for guidance, but other than that, you're going to court and you're arguing it yourself. Right? So at that point, terrifying experience, going to court without
First
even
time
being a
doing
lawyer.
it. Correct.
Yeah.
Yeah.
So it's terrifying at the start,
Yeah.
but that also motivates you to learn about the case and make sure you don't make a fool of yourself.
Yeah.
Right? And from then on, it gave me attachment to the cases I was doing.
I see.
Right? I felt invested in it. The client trusts me. We built a relationship there. And then each time we go to court, it's like a fight.
And also builds up your confidence.
Yeah.
And also your sense of fulfillment as well. When you
Fulfillment is the number one thing for me.
I see.
Right? Because each time you argue, it's like you're a boxer. Right? You're training for a fight and you want to win.
I see.
Right? And that is really the fun of law. Right?
So-
especially when the client
I see.
is on the same page as you,
I see.
appreciates the work you've done.
I see. And that's particularly relevant for lawyers they call litigators. Right?
Yes, it's disputes.
Because that is inherent in the actual
You're
act.
always involved in conflict. Yeah, right. But I think, I think a mistaken belief is that litigators are generally only involved in fighting. I think it has evolved quite a bit. Now, the court wants parties to settle even before bringing their case to trial. Right? And this is something I agree with. Right? I think there are a lot more cost-effective approaches to resolving a dispute than taking it straight to court. Right? I think you'll be aware. Legal fees can rack up quite substantially.
So a good lawyer would be one who is very capable and willing and able to fight very hard, but also pragmatic and prudent and far-sighted enough to say, perhaps let's take an alternative route.
Yes, I think a good lawyer should evaluate the case at the start and have an idea of the likely eventual outcome.
So that's already a very useful piece of information because I sense there's a big misconception around the impression that good lawyers are the ones that fight and only want to fight. And the sense, by comparison, would be a lawyer who tells me, as a prospective client or client, that I shouldn't fight is a weak lawyer and therefore a lawyer without confidence or who's incapable of fighting.
Yes,
and therefore not a good lawyer.
Yes, I get it quite a bit. Every time I advise settlement, the client sometimes asks, "Why aren't you willing to fight my case?"
I see.
Right? Do you not have any faith in the strength of
see.
my case? And what I tell them is, let's take an example, right? Your
Yes.
claim amount is 100,000, and we're going to fight this case for the next 1 year. and your legal fees are going to be, let's say, 50,000. Right? Your net return on that litigation is about 50,000.
And that's only purely from a financial standpoint.
Yeah.
When you factor in the time
Inconvenience.
cost,
Exactly.
18 months to recover this 50,000.
Exactly.
It might be worth a lot more, your 18 months.
So, I mean, I can write to the opponent, I can tell them, let's settle it now. I'll give a
see.
50% discount.
I see.
Right? You save all the time, you save the legal fees and uncertainties from litigation.
So I think that has once and for all, I feel, at least resolved this misunderstanding that a lawyer who proposes or is very keen to settle it in the interest of the client is not doing this out of weakness or laziness or any lack of confidence. Sometimes it is because it is the most prudent thing to do.
Yeah, I mean, put it another way, if the client wants to engage me for an entire trial, I'll be happy to.
Yeah.
Right? But, I mean, most of the time, I mean, I would say generally cases, about 80% of them will settle at mediation anyway.
Okay.
Right?
So we're getting into some deeper and I would say thicker areas of litigation, right? Where there are terms being used that some people hearing them for the first time may not know what they mean. Okay, so let's start from ground zero.
Okay.
Okay. And today we're talking about what they call civil litigation or claiming for sums of money.
Yes.
Right. Generally speaking. So in Singapore, there are many different layers and levels of court. Okay, I understand there's a magistrate's court, there's a district court, and there's a high court. But for people who are unaccustomed to this, what are the differences?
Okay, so if we start from the very bottom, we have the Small Claims Tribunal. So that is for cases that are below $20,000, or if both parties agree, your claim can be up to $30,000.
That means the amount that is being disputed and fought over
Yes.
is 20K and below.
Yeah. So
okay,
if you're
that's small
suing,
claims.
correct.
Okay.
The thing about small claims court is that lawyers are not allowed to participate,
Okay.
not allowed to attend.
Oh.
So that becomes a bit friendlier to people who don't have lawyers.
Okay.
Right? Smaller value cases,
Okay.
you can bring your case there. That's
Okay.
fine. After that, we move on to the magistrate's court.
Okay.
So that would be cases that are under $60,000,
60 and below.
60 and below, right? And then after that, we move on to the district court, which is above 60 but below 250,000.
Okay.
Right? And then we move on to the big brother, that's a high court, any amount above 250,000.
Okay.
Yeah.
So these are the 3 to 4 different levels. And
yes.
is it something so simplistic in the sense that if I have a claim, I just look at how much is the amount in dispute and will automatically select which level I go to?
Well, generally it is, but I mean, sometimes if you go to a lawyer, you might be able to claim more than you actually anticipated. Right? So
Okay.
a rough guideline, if it falls within the ranges I mentioned, that would be most likely your appropriate court. There are certain rules on which court you have to go to, but by far and large, those would be what you look at.
One last question on this, the segregation of levels, first before we go into some other hypothetical scenario type questions. Would the level of the court automatically mean more legal fees as well and or more complications? And related to that, would that be a relevant consideration or factor for a person choosing which level to have their case handled in?
Oh, okay. So I think the first thing we have to look at is cost. If you file a case in the high court, your court fees are generally going to be more expensive.
Okay, so maybe let's just slow down a little. Court fees and costs. For people hearing this for the first time, it's the same thing.
Okay.
But is it?
So, okay, maybe from now on, I'll say legal costs, which is the amount that you pay to your lawyers.
Your legal fees.
Correct.
Okay.
Right, so there's legal fees, and then there's also court fees, which is the amount you pay to the courts. Doesn't go to the lawyers at all.
I see.
Right, so for filing in the high court, you're usually looking at about 500 and up, just the amount that you pay in court fees. Right?
$500.
$500. And for, well, I mean, filing of documents is generally more expensive. I mean, about 2 months ago, I filed an affidavit that was $10,000.
Just in terms of the filing,
The court fees.
the
the
court
filing
fees. And so these are administrative fees.
Correct.
Not the time that you spent to prepare this document.
Correct.
It's what the court system will charge to accept and to have the documents filed.
Yeah. So as a general rule, the higher your claim amount, the more the court charges.
And so these are incidental costs already. They have nothing to do with your lawyer's work. That will be embedded into your total bill.
Yes.
So that is one way. Picking the right level is going to affect your case in terms of your spend, right? But in terms of the work that the lawyer does, is it automatically the case that a lawyer will have to spend more time working on a matter or doing things in a case that is in a higher level?
Well, I would say generally yes. I mean, the stakes are higher, and that usually warrants the lawyer being more careful, right? But I mean, there are certain cases where it's in the high court, but it's a very straightforward case,
Okay.
right? Owe money, pay money kind of cases,
I see.
right? Services rendered, invoices not paid, and no valid defenses.
That's a very good point that you touched on. So it sounds like the actual nature, level, and size and scale of the complexity also matters. Not just how much is in dispute. It could be a $400,000 claim, but very straightforward, and therefore not complex, and therefore not that difficult to do in terms of the legal work. But it could be a $75,000 claim, but very complicated, and therefore a lot of legal work and effort will have to go into it.
Yes, and the $75,000 example could be, legal fees could even be higher than the $400,000 claim.
Which brings us very conveniently to the next point, okay? So I have a hypothetical scenario, not just a one person, but many people who encounter a situation where they are owed money, either because of a breach of contract or unpaid invoices, where they have suffered loss, and there's a business disagreement, and they want to recover that money. Okay, so let's imagine that that's the scenario. So what would you tell that person, or what would you do if you were helping to plan around the person making the decision whether or not to sue, where to sue? Should I find an alternative way to get the money back?
Okay, so usually what I do first is I evaluate the merits, right?
Okay.
Usually this would be just over a short phone call. I just get the client to explain the case to me, poke a bit of holes in their case, and just see whether they have a valid case or not.
So merits of the case mean how strong or weak the case is,
Yes.
from a legal perspective. Okay,
Correct.
so that's one thing. Find out whether is there a good chance of winning in the first place.
Yes,
Okay,
whether they have any chance of winning. Let's put it that way.
So that's merits. Next thing in your thought process, what do you look out for?
Well, I look at the claim amount, right? So if we are talking about, let's say, a $300,000 claim, first I will look at the opponent. Who are you suing? Does he have the means to pay that $300,000? Right? Let's say this guy has no money in the pocket, no job, no bank account. Then is it really worth pursuing a claim?
Because even if I win the case,
It doesn't mean you get paid.
that's right.
Right.
Because he might have an empty bank account,
Correct.
and he might have no assets that you can try to realize or seize or to sell or to translate into money.
Yes, and I mean, if you do pursue the case, you get judgment, and the person has no assets, the most you can do is bankrupt him.
So if you expand on that, apart from just asking who that person is, how do lawyers and how can regular people who are not lawyers find out whether that person has money or not?
Okay.
Are there legitimate, lawful ways to do this?
It is very difficult to do that, right? But one of the things I look out for is whether the person owns any private properties.
Okay,
Right,
and
so
let's slow down. So how would you do that?
okay, so I mean, if you have the NRIC of the person,
Yes.
it's very easy to do searches on them, right?
Okay.
From there, you can trace their registered address. You can see whether they own that property.
Okay.
Right? If they do own that property, and if it's not HDB property, then you do have security there, right? That is your pot of gold. If
Okay.
you do win, you know that you can sell the house and recover your judgment from that
Very
sum
good.
of money.
So that's NRIC relating to property. But apart from that, any other things that?
Well, it becomes a bit difficult, right? Usually, I'll look at the person's background. Right? What kind of job are they in? Right? Do they have an established career? Because I mean, even if they have an established career, but they don't have any funds in the bank account, the threat of bankruptcy might still pressure them to make payment of judgment.
Sometimes we hear about lawyers doing searches, right? Searches, whether it's on ACRA, to find out whether they own businesses or whether they've been sued. What's the purpose of doing this?
Well, okay, so for me, firstly, to check whether there's any bankruptcy proceedings against the person or whether the person's already bankrupt.
Okay.
Right? Secondly, I like to look at how many cases have been filed against them in the past.
Okay.
Right,
So, how is that a useful piece of information to you?
Okay, so I mean, there have been a couple of instances where I receive where a client calls me up and says that, okay, this person has not paid for my services. Right? I'll do a search on that person or that company, and I'll see that there are 10 active lawsuits against them.
Against that same person?
Against that same person, right? And at that juncture, I have to go back to my client and say, look, this company looks like it's going down. I don't think you should be spending the money to pursue a claim when at the end of the day you don't get anything.
And that is the insight that you get from that piece of data,
Yes.
correct? Okay. What else would you be able to get from a search? I mentioned something about ownership and involvement in companies, either as
Yes.
officers or shareholders or directors. What information can you glean from that?
Well, I mean, usually if they have business interests, that usually means they are generally at times good for the money, right? There is a procedure, enforcement procedure, we call the writ of seizure and sale, where you can sell away a person's share in the company to recover the judgment.
I
recover the judgment
see.
debt.
So the fact that he has shares in other companies, not looking at whether these companies are actually worth money, but at a very simple level,
You
that
know there's
gives.
a potential source of recovery.
Okay.
Yeah.
Okay, good. So that's searches already. Okay. So we talked about merits of the case. We talked about whether the person that you're going after has anything for you to go after, right? How about things? You mentioned enforcement. How do you explore or assess whether there will be difficulties in enforcement?
Okay, generally it's a bit difficult to tell at the start of the case, right? But once, I mean, at the start of the case, you can rely on what we discussed previously, usually searches on the person, and just a brief background check on the person. After you get judgment, we have this process called the examination, where you get the person to come to court and disclose all his assets to the court.
So what you're talking about, this process called examination takes place after you have already won the case.
After you have already won the case.
And this is where you call the person who owes you the money
Yep.
to give information.
Yes, so bank statements, list of assets they own, whether they own any private properties, shares.
Okay, so once this has been given, what do you do with that information?
Well, okay, so I mean, there are a couple of things you can do. The first is if they have, let's say, $1 million in their bank account,
Yes.
you can get a court order against the bank to release that money to you.
What is that process called?
It used to be called a garnishee, now it's called an attachment of debt.
Okay, and this is a proper, commonly done process.
Yes, if you know that there's money in the bank account, that's usually the first thing you do. It's the easiest process.
Attachment of
Debt.
debt. Okay, good. That's one. What else can you do after you've done the examination and you've got information about what he owns?
All right, so if there's a private property, then you can do a writ of seizure and sale on the property.
On the actual property itself,
Yes.
not just the belongings.
No, so,
Not just the-
so
the-
that,
not
that is
just
another
the-
step. But
I see.
I mean, usually, if you're going to take someone's belongings, from my experience, it's not very useful because you're taking secondhand goods and you have to do an auction. The auctioneers charge a fee as well. The amount of recovery is not, it's not good.
Okay, so seizure and sale against the actual properties.
Yes.
So we've got attachment of
That,
debt. We've also got
seizure and sale of someone's personal items in the
Okay.
house. Seizure and sale of the house
of the
itself,
actual house itself.
provided it's not HDB.
Okay, and what else? What other enforcement mechanisms are there?
Well, I mean, you can do a writ of seizure of sale on someone's shares as well.
How about what sometimes people feel about or say that you can go after someone's salary if they are being employed?
You can't go on after someone's salary.
So that's not
protected.
So that's not something that you can do.
No,
You
that's
can't
not
say that because you're making very steady and fixed income in a full-time, long-term committed employment.
No.
I can ask the employer to pay me instead.
You can't do that for general proceedings. But I mean, if you know that the money is being credited into a certain bank account, then you can go after that.
Okay. Now the last one, before we move on into a slightly different area, but still related to the same topic, bankruptcy. Some people feel that when I've won the case and I've tried all these other ways to get the money and he doesn't want to, I will make him bankrupt. And there are two schools of thought. Some people will say that it's a waste of money because I will have to spend more money to make a person bankrupt,
Yes.
right? But another school of thought feels that by doing this, I put the maximum amount of pressure on him because the thinking is that most people will try their very best to avoid being bankrupt because there's so many inconveniences that come along with being a person who's made an undischarged bankrupt. That person would find whatever ways and means to repay you. What is your experience?
Okay, again, I look at the debtor, right? Because if this is a young person, say someone in his 30s working in the finance industry, I know that bankruptcy is going to put a lot of pressure on him to make repayments.
Because he needs to not be a bankrupt to continue working in the industry.
Yes, he needs a clean record, right? But
Correct.
if you're talking about someone who is, say, in their 70s or 80s, right, bankruptcy is not going to have much impact on their life because, I mean, I would assume that person is no longer drawing an income. Bankruptcy doesn't really do anything for them.
So even what you just said is very insightful because it means that having still comes back to that initial assessment at the very beginning of the case. Maybe even before you take on the case, you will look far ahead enough to understand the profile of the potential debtor to see whether there's any way that you can get any money out of him. How often do you see cases that should have gone through this type of analysis and evaluation before it reached you? Meaning, cases have come to you when it's a bit too late, when the process has already begun, they've already started to, or maybe completed suing a person who couldn't give them any money anyway. And then you have now been asked, can you help me get the money out of him? Do you encounter this, or is it just something that...
Right, I mean, I have encountered it, but I wouldn't say it is a very often.
Does it happen in fairly regularly?
Well, I would say it does, but I mean, I can't boil this down to their previous lawyers being bad. It's just a different change of perspective.
I think to be fair, it's not about their previous lawyers not saying to them, but I'm coming from the perspective of perhaps along the way, the profile of the person who owes the money also changed. Because maybe when he was being sued, his business was not going down yet. But during the case, which can take months or years, his profile has changed. And by the time you won the case, he maybe didn't have anything anymore. So my point is more to emphasize and try to find out whether it's important to continually assess the profile of the person.
Oh, I think I think the kind of situation that you just gave is quite uncommon. Right? And sometimes as lawyers, we're not actively doing background checks all the time. Sure. Usually, our clients will be the one that's most familiar with their opponent. If there's a change of circumstances, they would probably know.
Sure.
Right? And
okay.
Yeah.
So, but just to sum up this point, it sounds like at least the most appropriate and suitable point in time for this type of analysis to be done is really right at the beginning. This is really not something that should only be done after you've won the judgment and you've got a piece of paper saying that you can get money from another person.
Not after you've committed all the legal fees, court fees and all that. That's too late.
Understood. Okay, so I'm going to go through now some very common misconceptions of civil litigation. These are just statements that we've collected from people who have sent in questions, and typically we are inundated with questions along these lines, right? So the first one is, if I'm in the right and I have evidence, then I'll definitely win. And the point I'm trying to make is there's a difference between people feeling that they're morally or factually right or ethically right, and what the legal process would result in as an outcome.
Okay, so I think when we head into this kind of court cases, we have to understand that the one that is hearing the case is a third party, it's a judge. Right? You're presenting your version of the truth, and the other side is presenting their version of the truth. At the end of the day, it boils down to evidence and how the lawyer crafts the case. So it's not always the case where, even though you know that you are
morally right,
you get judgment. Right? I mean, the court will try to be just, but at the end of the day, they have to look at the evidence and the facts of the case.
So it's always about evidence.
It's always about evidence.
It's not about what is fair or not fair, or people like to say very often, as a matter of principle, who is right or wrong.
Well, I mean, sometimes that comes into consideration, but I mean, all your principles have to be backed up by evidence as well.
Yeah, and it's more about legal principles, less about these moral principles about who was right in the eyes of the community.
Yes, I mean, usually the court has to look at a precedent, right? So something that a previous judge has decided before.
Okay, second question, slightly more technical, a bit more administrative. There's a misconception that the losing party will have to pay all of the winning party's costs. True or false? Or what is the reality?
Well, generally false. in most cases, false. So usually what happens is if you win, you'll get a portion of your legal fees.
Okay.
Generally,
what does a portion look like? What does that really mean?
Generally about one-third.
One-third.
One-third of the total amount you pay your lawyers, right?
Okay, so let's expand on that. So it's 1/3. So the losing person has to pay 2/3 or 1/3 of the
One-third.
1/3 of the
Generally.
of the winning parties.
Yes. So I
Okay.
mean, how the court does it is not to look at the invoices that your lawyer sent, right? They'll just look at the case and then, well, they'll just decide, okay, I think that this case, the amount of legal fees that should be reimbursed is 50,000, for example.
Okay.
Right. So there is no formula for deciding how much cost should be awarded. It's all in the discretion of the court.
So the point and the takeaway from this is that even if you've won the case completely, you are not going to have all of your own legal fees to your lawyer reimbursed by the losing person.
Yes, in most cases. So there are some ways to increase the amount of cost that you're awarded, cost being the amount of legal fees that they have.
And without putting an exact figure on it, it's very, very rare to get 100% of your costs reimbursed.
Very rare. I would say that will only arise if, usually it's in the context of settlement offers being made, which comes back to the point I made earlier before, right? Always try and settle your case because, I mean, even now, it's in the new rules of court. The court wants you to try and settle before you bring your case to
Okay,
before you
that's
file
something that
lawsuit.
we'll come back to.
Yep.
So how is this useful information for a person who is thinking about suing somebody? This issue of costs, about recovering my own costs.
Okay, so usually I will talk about proportionality, right? How much are you suing and how much are your legal fees going to be, right? I think, let me try and give an example, right? Defamation cases.
Yes.
I think that is the most common cases I've dealt with where I have to drill this into the client.
And something
right?
that we'll talk about in a later episode.
Yeah, so, let's say, common example, a Google review.
Sure.
Right, a customer leaves a Google review at, let's say, a restaurant, saying that they don't find the food satisfactory.
Okay.
Right, the restaurant sues my client for defamation or sends a letter for defamation. Right. Generally, my clients would say they have the right to express their opinion. Right, there's nothing wrong with the review. Right, and it's at that point where I have to ask them, right? Okay, I understand that you have the right to your freedom of opinion, right? You have your principles, but how much are they worth? Because if you go through the entire court case, even though you win and you get reimbursed a portion of your legal fees, you're still probably going to have to pay at least 5,000 to 10,000 out of pocket just to keep the review up. And is that really worth it?
So, and that's on the low side already. It could easily be 2 or 3 times or 5 times that amount.
Yes.
And that would be the price of insisting on your principles.
Exactly.
Right? So, and I'm not saying that principles are not important, but I'm just trying to understand pragmatism.
Yeah. So I mean, some clients are they're willing to pay that amount, right? Then that's fine. Let's fight all the way, right? But once you break it down for some clients, they start to think twice. Right? Is it worth it? Go through a case
Which
for
is
1
the
year?
which is the second thing that I picked up from what you discussed. The first is that good lawyers are those that will actively explore and consider and help you evaluate whether settlement is a more cost efficient outcome and way of dealing with things. And the second is the lawyer who is able to help you not project but balance your costs and help you see why it's not worthwhile to pursue and win the case, even though you might have a very strong chance of winning, or maybe it's a certainty that you will win.
Yep.
But it may still be not worth your while to.
Yes.
Okay, good. There's a third misconception, which is about the speed of a case and the turnaround. Some people feel that my case will take no time and will be finished very quickly because our system is very efficient, but less so about that, but because my case is simple, right? But I'm trying to ask, even for a simple standard, say district court case, 200,000, 250,000, how long is the turnaround for that?
Okay, so
From start to finish.
It depends on whether there are any issues in dispute, right? For example, if it's going to be a straightforward case of you purchase goods from me, I deliver those goods to you and you don't make payment. In those kind of cases, you can typically get summary judgment, which is You argue before a registrar instead of going through a full trial.
I see.
And that process will take maybe about 5 to 6 months. Right? So that is the quickest. Right?
That is absolute quickest. And that's provided you are able to successfully
Yes. Argue your points and make it clear to the judge that there is no point in going to trial because it's so clear cut.
we have to, it is only sensible and correct to end the case now.
Correct. Okay, so maybe before that, there is another situation where the other side doesn't respond to your claim.
I see.
Right? So if you file a court claim, the other side has 21 days to file what we call a notice of intention to contest. Usually this means that a lawyer files a document to court saying that they represent the opponent. Right?
They acknowledge the case being started,
Yes.
and they also indicate that they want to participate and respond.
Yes.
Okay.
Right? So if that is not done, 14 days, not 21
Yeah.
days. 21 days is out of jurisdiction. So if that is not done, you get what we call a default judgment, which is sort of like an automatic win. Right? The court takes it that since your opponent didn't file any documents, they accept that they are liable for your claim.
And it's like a walkover where you're
Yes.
disqualified. The opponent is disqualified. You
Correct.
can't participate anymore.
Correct. So that's the absolute quickest
Okay.
result, right? 14 days.
So it's only in that situation that it's really fast. Otherwise, minimum 6 to 8 months or thereabouts.
Well, about 4 to 6 months for summary judgment, but again, it's a quite expensive process.
Now, if
it
it-
goes all the way.
And if it takes the entire process to finish, what does that look like, including trial and before trial, pre-trial,
Okay.
post-trial, and appeal?
Well, I mean, it depends on complexities in the case. Right? The more complex the case is, generally there's more court applications you have to file. That drags on the entire process. Right?
Okay, so a very quick detour to talk about what are these other applications. So and there are many words that people will see online when they Google things like interlocutory applications. What do interrogatories? Asking for particulars, discovery. These are things that non-lawyers always see when they start to research for their case. What do these terms mean, and how do they extend and can they impact the timeline of a case?
Okay, so I'll try and boil it down. Usually, when you start a lawsuit, you don't have all the information that you need to fully present your case.
Okay.
Right, so this is where interlocutory applications generally come about. Right, the most common would probably be discovery.
Okay.
For example, I would say, let's give an example. Right, my opponent says that he did not receive any money from me in April 2020, right? A document that would be relevant for me to verify that would be to see his bank statements. And I can use the discovery process to make a request for his bank statements, and if he refuses, I'll go to court and fight it out.
And that's why it can be done. You can make a very polite and quick request and he can voluntarily comply, but assuming that he doesn't, that can be a mini fight in itself.
Yes. So, I mean, there are many applications like that. Generally, now the courts have implemented this thing called a single application pending trial.
I see.
So they try and get all these interlocutory applications and put it together. So you don't
Have
it's
multiple.
not a case where you have multiple stages.
So, are you saying that with the new rules in place now, we will have less of these multiple repeats of the applications being done?
I would say so. I would say that would definitely expedite the whole process, but we are still looking at usually the minimum 1 year, at the very minimum.
And is that with or without something they call an appeal, which is basically when
Without
a
an
person
appeal.
disagrees with the outcome and wants another higher court to take a second look at it?
Without an appeal. I mean, with an appeal, we're probably looking closer towards 2 years at least.
I see.
Yeah.
So that is fairly safe snapshot of a timeline for it.
Yeah, I mean, 1 year, I would say you're being a bit optimistic as well, right? But generally, the soonest you can get it is about 1 year. Also depends on how many days of trial you need. Right? If you have 1-2 days, a lot faster than if you need 30 days of trial.
Last question for this section. We touched on this earlier, and there's a very typical impression and misconception that we encounter, which is a court judgment that I have guarantees payment for me.
Not true. So, I mean, you got to look at it this way, right? If the person you're suing has no money at all, how do you expect them to pay? Right? They need to pull it out from somewhere, right? If they don't, your only option is bankruptcy.
And even bankruptcy may not give you the final objective that you want, which is actual, well, unless what you want is not money, but to send a message
Yeah.
or to inconvenience a person in terms of his activities and his livelihood, that could be an objective, right? But if your objective is to get money, you're still not going to get it.
Yes, and I mean, usually, okay, how bankruptcy works is that they look at how many debtors you have and how much money you owe, right? And they do a proportionate distribution to all the creditors.
Again, another
So-
subject matter I will
Yeah,
invite
so I
you
mean,
back to have a longer
without going
conversation
too
about.
deep into it,
Yeah.
usually when someone is bankrupt, the amount you get back is going to be a fraction, if anything, of the amount you
Last question before we start to wrap up. You mentioned something about how the courts have always been encouraging people to settle because it's more efficient, not because they don't want to do the work, but it's better for everyone overall in terms of saving time and cost and resources. And even if that may mean that you don't get as much as you would if you had to litigate the whole thing. And you mentioned something about the new rules, the new courts rules, either encouraging it or mandating that the settlement needs to be explored.
Yes.
Can you tell us a bit more about that?
So the courts nowadays, they encourage parties to settle as much as possible before bringing the case to court. Right? It's sort of like the court telling litigants, I'm too busy, I have a lot of cases to hear, so please try and resolve it between yourselves before you bring it to me. Right? So this is very useful for us as well because, well, there are consequences for rejecting a reasonable settlement offer. Right? So let's go back to another example, a $100,000 claim. If I send the opponent a settlement offer for $50,000 and he rejects it, and we go to trial, right, after 2 years, right, spending $100,000 in legal fees, the court says, okay, the opponent has to pay my client $100,000. Right? That gives me an opportunity to tell the court that I actually offered $50,000 2 years ago. Right?
It would, have
didn't
saved
pick
us, it would have saved us all this hassle.
and it would have saved the opponent so much money because the opponent could have accepted $50,000 instead of now paying $100,000. Right? And if the court hears that, what they'll do is punish the opponent, and that is usually by increasing the amount of cost that the opponent has to pay.
I see. So instead of the 1/3, it'd be more than that.
maybe 2/3, it could even be full.
I see.
Yeah. So yes, that's what I always do.
And to be clear, it's not because the courts don't have the time, but I think impression and I think the reality is also that a lot of cases can benefit from settlement
100%,
because the energies, the kind of intangible resources that go into managing and to, implementing the case, or rather I should say executing the case. Whether it's lawyers, the court officers, the court system, the people who are all behind the scenes. There's a lot of resources that go into a case going from start to finish. And that can be saved by being more pragmatic and having a compromise.
Yeah, I mean, at the end of the day, it's cost-effective justice. Right? How do you resolve the issues with as little time and money as possible?
Okay, perhaps I lied. There's one other question that came to my mind, and it's tough to have a short answer to this, but if you can, just share your insights. Are there cases where it is not as easy to settle and be pragmatic and to compromise, and it is probably better to litigate?
Yes, I would say there are many cases like that as well. I mean, typically this would involve the claimant or one party suing the other party for money, and that same counterparty having a cross claim, having a counterclaim. Right? Those kind of scenarios, it becomes a bit more difficult, especially where the case is a bit emotional. Right? So usually there are a lot of things like family disputes, right? Fights over the ownership of a property, right? Usually it goes beyond money. It's really tugs at their emotions, and that makes it harder to settle.
Coming to an end, just wanted to ask you, what are the 3 tips that you would give to a client working with you, or generally a client working with any lawyer? What are the 3 things that you would recommend and remind that person or suggest that that person do to help them have a smoother case or smoother relationship with their lawyer?
Well, I think firstly you have to be very transparent with a lawyer. You have to be open.
Don't hide anything.
Yes, the facts are known to the client. Any adverse facts, any not so good evidence, you have to let your lawyer just say everything, so your lawyer can advise you how best is it to navigate those issues.
That's one.
Right. Second, I think you need to know what you're getting yourself into, and usually this would be legal fees. Right? How much do you expect to pay for the entire suit? What happens if you lose? right? Because you might be suing someone for $100,000, you pay, let's say, $60,000 in legal fees, and at the end of the day, you lose your case, right? You end up being out of pocket another, you have your $60,000 to your lawyers, and as well to the other side, so let's say $90,000, right? The third, I think you should always ask for an evaluation of what the likely outcome, right? I think get your lawyers to start working at the start of the case so that they can tell you where you're likely to be headed, right?
Do the analysis thoroughly and well at the start.
I mean, there might be more legal fees up front, but I think it's worth it, especially before you start the case.
Because that might also be the difference between not just what path you take, but whether you even start on that path at all.
Yes.
Because done well, the analysis might actually enlighten you to say, I should not sue this person.
Yes.
And maybe that is what you need to know.
Yes.
And that is worth the money that you pay to get that information.
Yes, because once the matter goes into court, it's a lot harder
Because
to
it will
withdraw
save you the heartache and the pain and the blood, sweat, and tears that you will have to incur much later on.
Yes.
Okay, thank you very much. 3 quick fire questions. First, biggest misconception clients or people have of you as a lawyer or of lawyers in general? Misconception. People don't understand.
They're out to suck your money.
Number 2, if you had a lawyer superpower, one that you don't already have, what would you want?
I want to read someone's mind. Then that will make questioning a lot easier.
Wonderful. Okay, last one. $1 billion today, tomorrow, would you still be a lawyer? Yes and no, and why?
I think I would, but I will probably choose my cases and only those that really bring me enjoyment, right? So I can just focus on those few cases.
Wonderful.
Right.
Thank you so much again for today's chat. We've covered a lot of ground, and I think there's a lot of information that people hearing about litigation and claims and the court process would definitely benefit from. As I said, I'm going to invite you back for a number of other conversations, so
Sure,
I'm going to
looking
be
forward
talking
to
to
it.
you soon. But again, thank you very much for spending this time with us. Can you tell us where is the best place for people to connect with you if they don't already have any interaction with you?
Well, I mean, you can find my contact details on my website. I'm from PDLegal. So yeah, just do a search on me, Ivan Lee, and then you'll find my contact details there.
Wonderful. Thanks again for your time. If you've enjoyed today's session, don't forget to subscribe and follow us for more legal things.